Do I need to sign in?
Good morning.
No, you don't, because you're on the board.
It's just James. I figured we'd have more people.
Well,
I will steal somebody's soda, but I will steal the water. Hi, guys. Not today. Good to see you guys. I need you to read that before we get started. Then pass it over to Paul afterwards.
The weather advisory.
They have a child missing alert in Edmonton. So anytime somebody rolls on the cage tower there, they get that freaking alert.
Okay.
Yeah.
Mark, you all set with the package, or do you have one?
No, I don't have one. I never printed it out.
Okay.
I read it though.
Yeah, I'll just give one to you.
I printed it out. That was it. Did you read this? There is a section in there where you.
When the red signs are in the same one, so they're it's probably recording. What? Some risky.
It's such a
Annoying.
feedback is so annoying. I get such a visceral.
C'est bon, ça, c'est bon, ça.
My accounts, I'm like, I don't want to be responsible for that.
Oui, mais après, nous autres, on va faire, après faire une lettre à ce moment-là, c'est que c'est un adulte différent. C'est un étranger qui a fait ça.
Si on prend la ça donne du talent.
Non.
Lui, je pense qu'il a besoin de ça. C'est lui qui a square footage.
Ouais, mais.
Il faut qu'il fasse avoir.
You guys see this okay?
Je pense qu'il faut intéresser.
Moi, j'ai gagné. Moi, je suis satisfait du succès.
I would say probably speak up there
Ça
when
fait
you're
30 ans
talking.
qu'il est là.
Because the mic is all the way over
Fais
here.
des choses, Blanca.
On the laptop.
Je fais ça parce que
Wow, you're way up over there. You're not gonna hear me with this.
Talk louder.
You might talk loud.
Moi, je te dirais ça.
We'll just get closer since we don't have anybody else here. Get you out of the shot.
Thank you.
c'est ça, mais il dit.
Non.
Sometimes it's nice to
Moi, je chante pas. Le reste, ça
get you out of the shot.
Oh, mais ça va être.
You'll be safe.
So used to being in front of the camera, it doesn't bother me. I was just teasing you.
No, it's fine. When I put it there, it doesn't see your hair.
He's there?
He's in Florida.
I don't want to see me, I want to see them.
Oh, God.
Oh,
You can see them if you sit here.
c'est chum à gueule.
Uh-huh.
C'est chum à gueule.
Okay. We'll record it. It's recorded at the bottom. Share screen. That way you have to click in order to.
Is everybody here that needs to be here tonight? Can you guys hear us all right over there? Mr. Care?
Can you guys hear me?
Yeah, I can hear you. Can you guys hear us?
Yes, we can.
Okay. Okay, we're gonna call this article number 1, called the public hearing to order, and it was actually 5:30, right on the money. We're gonna establish a quorum, which we do have. There's 3 of us here, 3 out of 5, or actually 3 out of 4. Determine conflict of interest and or bias. Anybody have any problems with the case?
No.
No, I don't have any problems with them.
Well, I have a question about bias, and it's pointed at you, Mark. With
Go
the
ahead.
presentation that you did the other day and telling us that you're working for Gary Picard, I don't see how you can be unbiased in any case with us, or if it's like that with everybody else. I think that that disqualified you in any hearing, especially with us.
Well, if you want me to step down, then I can step down.
Well, I believe that the way it's supposed to work is, I tell you why I believe you're biased, and when you told me that you were working for Gary Picard, that tells me that you're biased.
I don't work for Gary.
But the next step is that the board, the rest of the board has to vote on whether or not that you should step down or remove yourself in the hearing.
It's up to you. If you want me to remove myself, I can. It's up to you.
Well, I make the claim, and then they have to vote and determine whether or not that my belief that you're biased based on the determination that you're working for Gary Picard, that you should be removed.
Okay.
But they have to vote. They have to vote and determine that. I'm
Well,
going by the manual. Do you have your manual over there?
Not offhand, no.
Should have your manual.
Well, what's your definition, Vic, about work?
What's that?
What's the definition? You say that he works for Mr. Picard. What's
Yeah,
the
he
definition
doesn't
of
work for Mr. Picard.
No.
I work for the people of the town of Madawaska, but I still got to answer to Mr. Picard if there's any issues.
The problem is that Gary Picard is a problem. Gary Picard has been causing all kinds of problems. And if he's working for Gary Picard, then he should be removed because there is an issue of bias there. And that was made pretty clear at the last meeting that we had when you went on with your rant for 15 minutes, telling us that we'd be hauled off to jail or something.
I don't remember anything like that. Do you remember anything like that, Mr. Ed Bear? At the last meeting?
I don't remember much about that last meeting. I thought it was pretty hectic, and there was a lot of flaring tempers. But I don't remember any particular comments made by any particular person, Mr. Chairman.
Okay. Oh, again, I'll ask you again, Mr. Carey. Do you want me to step down? If you feel that I am biased, then I'll be more than happy to step down.
How many members are you over there?
There's only 3 of us.
Well, if you step down, then we can't have a meeting.
Exactly.
I'm sorry I joined late. What's the basis for the challenge that the chairman of the board is biased? Is it simply because he made a comment that said that he worked for Gary Picard? Is that the entire
Yes.
of your claim, Mr.
Yes.
Chair?
Well, that part of it, and especially the 15-minute rant that went on after that, before we were even allowed to speak, I believe should disqualify him for any meeting with us.
Well,
And it's not up to you, Mr. Barrett.
no, I know it's not, but I'm certainly here to advise the board, Mr. Chairman. Please don't pick any fights with me tonight. I thought the last time around you were a bit too offensive with your comments, and I just hope that you can make your points as they need to be made tonight without going too far outside of the rails here.
Well, I have another question. Mr. Barrett.
Mr. Chair, why don't you sit quiet for a minute? I'm going to talk to the board, and we'll get back to you.
Are you representing the board or Denise DeBarry in this hearing?
I'm representing the board. I'm assisting the board. I don't think that Denise needs any of my help. Mr. Chairman, if a request is made or an allegation is made that a member is biased, that member obviously can choose on its own accord to step down. Otherwise, it should be put to a vote. Bias would mean that you are unable to make a fair and dispassionate decision about anything involving Mr. Care. Doesn't have anything to do with Mr. Picard. He's not a decision maker in this process. This is an appeal from the code officer's decision. It has nothing to do with the town manager. Bearing that in mind, I would ask that either you acknowledge that you do or don't have a bias, and then let your fellow board members vote on it so we can move on if we're going to, or adjourn the meeting for lack of a quorum otherwise.
So I'll let either Dan or Paul over here make a motion to say that whether or not I was biased on the last meeting or not.
Is that the type of vote that's necessary, or the type of motion that has to be spoken before any vote is taken?
I'd like to make a motion that Mark remain on the board.
I second.
I can't pass it forward.
All in favor?
All in
All in
favor?
favor? Can we continue now, Mr. Care, or do you have something else?
I couldn't hear what you people were talking about, and because Mr. Ed Bear told me to keep quiet, I didn't say anything, so I don't know what you guys have been talking about.
We just agreed to keep Mark on the board. Actually, we had talked a while back about allowing you to, we were just talking, to have a permit upon DEP approval. And that's how I know that Mark isn't biased. And some things that changed there, and that your permit needs to go through the DEP first, and so it's changed there. But that's how I know Mark isn't biased, because he's the one that brought it up. We wanted to approve you at first. So.
I'm afraid I can't hear you. You're gonna have to speak up clearer, or we can't hear.
You have to take your mask off.
We
Face the camera when you're speaking, the laptop, because that's where the mic is on the laptop.
Can you hear me now?
Yes.
Okay, we decided to keep Mark on the board because I know for a fact that he isn't biased. We talk regularly, and I know this in my mind, that Mark is not biased. So we decided to keep him on the board.
But it should not be based on what you guys are talking about, which is ex parte communication. If you're talking about me, it should be based on my contention or my belief that he's biased, and based on the reasons that I just stated. Basically, the 15-minute rant that was on at the last meeting that we had is enough for me to determine that he's biased. It has nothing to do with what you people have been talking about, ex parte communications.
Well, Mark's staying on the board, so you're gonna have to deal with it. You know?
We took a vote, Mr. Care. Can you hear me okay?
Yes, I can, Dan.
Okay, we took a vote, just like was suggested by Mr. Bear, and to see if he should step down or not. And the motion was put in, we took a vote, and it was decided that he would stay on.
Good enough?
Was there anything else before I continued on the article, on Article 4?
No, go ahead.
Okay. Article 4, to hear an administration appeal application received on October 19, 2021 by Richard Care, map 034 lot 0020 in the shoreline zoning 57 Chapel Road, St. David, Maine. So what would you like to do now that article number 4? What is the problem or dilemma that you have with Denise?
Okay, well, if you look at my October 14 letter addressed to Marcia, Dan Fortin, and Paul Lovewood, is that Paul Lovewood with that on there?
Yeah. Yeah.
Is that the same Paul Lovewood that was at the last meeting, or there seems to be two?
There's two of us at the last meeting. There's two Paul Lavas.
Well, no, the last meeting that we had with him, with Mr. Care and Ann, was us 3.
Okay.
The last particular meeting that we had was with, somebody on Pine Street. That was the other.
Oh, yeah,
that
that
was
was Lynn.
then- yeah,
Yeah,
then
okay,
yeah,
yeah.
Lynn was here, and that was all 4 of us were here at the time.
Okay, yeah.
But I believe he's working tonight, that's why he's not here.
That's the same one that was there at the last time. Okay. Now, do you have that October 14 letter before you?
Yes, I do.
Well, I've got September 14th.
Yep. Are you talking October or September?
This one.
Are you talking about October or September?
October.
October 14th.
That would have been after the letters. I got October 25,
October 25.
October 19th. Do we have a printout of that October 14th letter that he's talking about?
Should have been in your packet that I emailed you. And it's the same one that you received in the mail by Mr. Kager.
Yeah, and that's what I'm looking at here, but it doesn't say October 14th. It says,
September 14th.
No, it's dated October 14th.
Okay, I've got the October 14 one.
okay, so
Yes.
we went past it.
Yes, it's,
Okay, I got it.
Do you want my copy?
All right, here, got it.
okay.
We're all set.
Okay, we had 2 of them from you, and coincidentally, one was September 14 and then one was October 14. That was a mix-up. Okay, we are on October 14 letter.
Okay.
Thank you.
Mhm.
This request was because the CEO's decision denying us our right to a Board of Appeals hearing. That was one issue. There was another issue, and it was because denying us the right to a planning board meeting. Our contention is that when we file an application for a planning board or the Board of Appeals, the code enforcement officer does not have the jurisdiction or the authority to deny us a hearing. Only the planning board or the Board of Appeals can make that determination. That's why it's mailed to the planning board and or the Board of Appeals. Now the issue is, I'll read the letter on September 14, 2021. I sent the 3 Board of Appeal members letters requesting a hearing. On September, I put 21 is 21. The new CEO Denise Dubati denied us our request with the Board of Appeals. We assert that the CEO Denise Dubati does not have the authority to deny us an appeal of her decisions. For these reasons described below, we request a second time for a de novo review of the CEO's action. And that's what this meeting is about. We would like to determine that the CEO's order decision.
What happened? You just stopped there, Mr. Care.
Yeah, somebody spoke up for.
Okay.
I'll I'll start again. Number one, determine that the CEO's orders, decision, determination, and requirements of the greatest practical extent constitute a conflict of interest and violates our due process and equal protection rights. Our request with the planning board was made based on, where's that? On the June 2 meeting that we had with the planning board. At that time, the planning board told us that we had to file an application for a recreational vehicle permit, and we had to file an application for a permit in order to place a recreational vehicle on our property. And the minutes of that meeting ended with saying if it does not meet the 100-foot requirement, they can decide on the greatest practical extent, or Board of Appeals may grant a variance. So because we were told to file an application for a permit to place our camper on our lot, and that it was determined that it was within the 100-foot setback, we believed that we had the right to meet with the planning board so they could determine the greatest practical extent. Now, the issue here is, there's two issues here just with this RV on our lot. First, we have observed for all our life here that campers were placed within 100 feet of the high water mark all along the shore in Madawaska. And it was still being done last year. The second issue that
Do you have, hold on, I'd like to stop you on that one. Do you have photographic proof of these campers being within 100 feet of the high water mark?
Yes, I do, and I gave those to the town in 2010 when they brought an enforcement action against us. We took pictures of all those campers and provided that to the board. In fact, we also met with the board, and they told us that Lloyd Tardif was a selectman at that time, told us that Big Care, you're not going to stop us from placing campers on house and camp lots. And Bob Williams was a selectman, told us that as long as it was licensed and on wheels, and that's all in the minutes in the Board of Selectmen meeting. And we've also provided those documents to the town in 2010, 2011, throughout that case that they brought against us.
Is there, hold on, why, Mr. Kerr, is there any truth on that, Gary? You never went back that far in the records or anything like that? Yeah, because from my understanding, reading the shoreline zoning laws again, okay, basically the practical extent is anything to do with a structure that is already there. Existing structure that has been grandfathered before DEP became into existence through EPA. That's where the greatest practical extent is coming from. But if there is no structure there, everything is supposed to be 100 feet away from the high water mark. Campers and all. Okay, and that's where the Kayers are getting upset because other people were putting stuff at 60 feet, 75 feet, and no. That's not within greatest practical extent. Okay? So I mean, I keep reading that same thing over and over again from Colin Clark, and it finally clicked. The grandfather clause that comes into the picture of any structure, like Mr. Gogan's structure over there, if he wants to remodel it, he's got to go through proper channels, the planning board, Board of Appeals, to get his permits to be able to do whatever he wants to do with the place, as long as the structure stays there, or he stays over 50% of the value of the structure. So the grandfather clause is actually attached to that structure, but once the structure moves off the lot, the grandfather clause goes with it. It's gone. Okay? So I do understand where the cares are coming from if they have photographic documentation of this from back in 2010. I'd like to get a little more information on that to see how true that is.
Well, it doesn't really matter because.
And not in this case, no.
No, because what's happening now, it was an empty lot. So you gotta go with the.
Well, what happened with his lot now is that in 2012 is when he was gonna put up his new structure over there. Okay, and that's what happened. And because the old structure that was there, the old red camper that was falling apart and growing leaves and trees on it, was grandfathered to that particular lot. Once that got removed, the grandfather went out with it. Okay, which now everything switches over to the greatest practical extent of 100 foot from the high water mark, which you can't put anything within it, according to what I've been reading from DEP and inquiring about it. Okay, that's what ends up happening.
Mr. Kerr, did you get in touch, if I can ask, did you get in touch with DEP to get some rebuttal, some explanation?
Yes, I did.
And what did they say?
First of all, am I going to be entitled to a fair hearing here? Because Mark is doing exactly the same thing he did the last time.
No, I'm not. No, I'm not. I'm following.
I'm supposed to be able to present my case here without interruption.
Okay, go ahead. I asked a
Will you
question.
go ahead?
I asked a question to Gary about this, what you were talking about in 2010. If he knew anything about it, he did not. There was nothing wrong with asking a question.
You didn't ask a question. You went down with a rant again, with your interpretation of the code.
Okay, then you go ahead. Now it's your turn.
Okay,
Without interruption, please.
Go ahead.
excuse me, one more interruption, Mr. Kerr. Do you want to read numbers 1 through number 8? And then we'll discuss it? Okay, because this is all, from number 1 through number 8.
Let's went to number 8. That's one to number 8 about what the.
Number 1.
Well, there's number 1, then there's number 2, all the way down to number 8.
It's on October 14th.
Okay.
It's numbered over here.
You want me to read that, all of that?
Well, without interruption, if that's.
Oh. Okay. Thank you.
You're welcome.
Can I start over again now?
Sure.
Go ahead.
Determine that the CEO's orders, decision, determination, and requirements of the greatest practical extent constitute a conflict of interest and violates our due process and equal protection rights. Determine that the CEO's denial of our request and filing for a Board of Appeals hearing is also a violation of our equal protection and due process rights. Overturn the CEO's decision to deny us our meeting with the planning board and allow the planning board to determine the greatest practical extent from the high water mark of our recreational vehicle on our legally non-conforming lot 468. Determine that the CEO's additional duties as the administrative assistant is a conflict of interest, violating our rights to equal protection and due process. Determine and overturn the CEO's orders, decisions, determinations, and requirements that the legally existing non-conforming lot 468 is not a legal lot of record in the residential district, and that it cannot be used as a campsite for a recreational vehicle within 100 feet of the high water line. Determine and overturn the CEO's orders, decisions, determinations, and requirements that the legally existing non-conforming lot 468 is not a legal lot of record in a residential district, and that it cannot be used to store a recreational vehicle. Determine that the legally existing non-conforming lot 468 is a legal lot of record in a residential district, and that it can be used as a campsite with a camper within the 100-foot setback. Number 8, determine that the illegally existing non-conforming lot 468 is a legal lot of record in a residential district, and that it can be used to store an RV/camper within the 100-foot setback. Number 2, request for a Board of Appeals review and overturn the CEO's decision denying us our right to a planning board meeting. And the letter on September 7th, 2021, the CEO, Denise Dupati, issued a notice of violation for our recreational vehicle camper on lot 468. In her notice of violation, she informed us that our RV was in violation because it was closer than 100 feet from the high water mark of the lake. In an email, we explained to her that we were allowed to have a camper on our lot because it was a legal lot of record in a residential district. We then asked to have the planning board grant us a meeting in order to determine the greatest practical extent from the high water mark of the lake. In her September 7, 2021 email, CEO Dupati denied us the right to have a planning board meeting to determine the greatest practical extent from the high water mark of the lake. CEO Dupati claimed that the planning board abdicated their responsibility to determine the greatest practical extent and illegally transferred that power to the CEO. As the town code enforcement officer, it is not within the CEO Denise Dupati's authority to deny us a planning board meeting. This is a planning board decision or determination. Furthermore, by denying us our right to a planning board meeting, the CEO has willfully violated our due process rights. This willful act is clearly seen by us as an intentional act in bad faith, violating our constitutional rights of the 4th and 14th Amendment. Moreover, because we have pointed out to CEO Denise Dupati that many other property owners within the town of Madawaska have always been allowed recreational vehicles within 100 feet of the high water mark of the lake, we see this as a willful violation of our right to equal protection. This rights violation is also contained within the 4th and 14th Amendment of the United States Constitution. For these reasons, we are requesting a Board of Appeals hearing for a de novo review and to overturn the actions of the town CEO Denise Dupati willful violation of our equal protection and due process rights, denying us a meeting with the planning board and a hearing with the Board of Appeals. We are also requesting a Board of Appeals hearing for de novo review and to overturn the actions of the town CEO Denise Dupati's decision denying us our right to place our RV camper on our camp lot 468. We are also requesting a Board of Appeals hearing for de novo review and to overturn the actions of the town CEO Denise Dupati's decision denying us our right to store our RV/camper trailer on our camp lot 468. We are also requesting that the Board of Appeals determine if the CEO's decision and actions against Richard and Ann Cater's rights to camp in their RV and to store their RV on lot 468 was justified and consistent with our enforcement of similar alleged violation and or rules. Determine if these actions by Dupati was intentional selective enforcement. E.g., has the CEO taken similar enforcement action against other owners of RVs within the 100-foot mark and prevented other land owners within town shoreline zones to store their RVs on their lot within the town shoreline zone. This determination must be referenced on the September 6, 2016 dismissal with prejudice for the 2010 RV violation and res judicata. To to determine if the CEO, Denise Zubati, has intentionally harassed and or violated the caterer's rights to equal protection and due process. To determine that the CEO, Denise Zubati, has intentionally harassed and or violated the caterer's rights to equal protection and due process to illegally take our property without just compensation in violation of our Fourth Amendment right. To determine if the Board of Appeals should report to the Board of Selectmen for sanctions against CEO Denise Zubati, and to determine if she should remain as the town CEO.
Okay, I know you guys over here, are you all done, Mr. Care? Or did you have more to add?
Well, I'm all done with this presentation, but however, there will be other issues that we will have to be discussing. Now, I think I'd like to help in the sense that, are you familiar with Chapter 1000? And do you have a copy?
No, I don't happen to have a copy of Chapter 1000 with me right now.
Mr. Chairman, Chapter 1000 is essentially the same set of rules on a state level that the town has adopted in the shoreline zoning ordinance.
Okay.
While I have the floor, I want to just add a couple of comments to try to move things along. Whatever you see in Mr. Care's appeal or reference to his due process rights or taking, etc., that is not within this board's jurisdiction to determine. You've got to be a judge to make calls on whether somebody's constitutional rights have been violated. And furthermore, when the code officer issues a notice of violation, it is an enforcement action, and pursuant to section under appeals procedure on page 35 of the ordinance, enforcement-related matters are not appealable to this board. But to the extent that this appeal relates to the notice of violation that was issued by the CEO, it's not a matter that this board has jurisdiction over. There are no constitutional issues, no enforcement issues are before this board tonight.
I disagree with what Mr. Bear said. There are many other issues.
Yeah, I'm not suggesting that there aren't other issues, Mr. Care. It's just that if it's a constitutional issue, which is what you have cloaked a lot of your concerns in, or if it's a challenge to the notice of violation, it's not for a local board of appeals to make determinations on those matters. Likewise, while I'm at it, it's not for the Board of Appeals to determine whether or not there's a conflict of interest because Ms. Dupree may hold a couple of positions with the town, whether she should be sanctioned by the select board for any of her actions. That's not something that the zoning board of appeals deals with. So those issues are just plainly not within the board's scope of review and should just be dismissed summarily by the board.
Are you done, Mr. Bear?
I am right now.
Okay. An example to show that Mr. Bear is wrong. Denise Zubati, as CEO, told us, instructed us to remove our camper from our property, even if we were not living in it and we were not able to store it on our property. Now, this was not a notice of violation. That was a determination made by the CEO, and her determination was not based on any statute, ordinance, or precedent in the town of Madawaska. The removal of our camper was not an enforcement action. There was no notice of violation saying that we were in violation after September 16th because we removed the camper. She could not have given us a notice of violation. And that is definitely a determination by the code enforcement officer that is appealable to the Board of Appeals. Now, the other thing that I would like to address here is that if you would be able to look at Chapter 1000, the town adopted Chapter 1000. I am willing to agree that many of the things that I put in there was based on the fact that camper trailers have always been allowed, and it was told to us by the selectmen that we would not stop them from allowing campers and trailers on house and camp lots. Because it was always allowed, we believed that we were entitled to do everything that anybody else was doing if we were not violating any or going beyond anything that anyone else, in other words, equal protection. Now you can determine equal protection. What I'm getting at here is that Denise Jupati's notice of violation forcing us off our property when she is well aware that there are many, many campers and RVs on house and camp lots within 100 feet of the high water mark, within and beyond the Chapter 1000 rules. Now, the Chapter 1000 rule number 2 we've just adopted says that if you have a camper on a house or camp lot or another use on that property, both of those have to meet the dimensional requirements for both of those. In other words, if you have a house and a camp within shoreline zoning, you have to have 40,000 square feet. That Chapter 1000 also says that if you have a recreational vehicle, you must have, for an individual private campsite, you have to have 30,000 square feet. That would mean if you have to meet the requirements of both of those, you have to have 70,000 square feet, pretty close to 2 acres, before you can have a house, a camp, and an RV on that lot. And you cannot have those within 100 feet of the high water mark. And I talked to Colin Clark yesterday. He made that very clear to me that you cannot get a variance for that, and there is no exception. Nobody can do anything beyond the Chapter 1000. So what I'm willing to say here tonight is that if the town of Madawaska is going to enforce Chapter 1000 against us, we are asking that they apply it evenly to everybody else so that there is equal protection under the law and that everybody's treated the same. Now, there's a section in the municipal handbook for the code enforcement officer about selective enforcement. Selective enforcement means that they could theoretically say that we're going to ignore everybody else's violations and hone in just on Richard and NKer and bring an enforcement action against them and not against anybody else when it's in clear view. When you're driving down the road, you see all these campers not meeting Chapter 1000 requirements. So let me read selective enforcement. If a municipality has been lax in enforcing its ordinances and then decides to prosecute a particular landowner for violation, a violator may argue that the municipality is selectively enforcing the ordinance and unconstitutionally discriminating against him. The courts have held that to prove discrimination, the violator must show that the enforcement action against him, quote, was a conscious, intentional discrimination and not an attempt to begin reversing intentional discrimination and not an intent to begin reversing historically lax enforcement. And the court cited Alexander v. Town of Hampstead. Now, what this is saying, what I'm saying is, if we are going to adopt Chapter 1000 and prevent me and everybody else from meeting all 30,000 square feet and the requirements for the area for both the resident, the house or the camp, which is 40,000 square feet and 30,000 square feet. If we're going to meet all of these issues, all of these requirements under Chapter 1000, I have always been willing to say I will follow the law. I will not argue about that. That is the law, that is the ordinance, it should be applied. It's being applied against me, and it has to be applied with everybody else, including what the planning board made us do, was file a permit application for an RV. So if everybody that has a camper along shoreline zoning within 250 feet of the lake, it's going to be very easy to say one thing. If you see a camper anywhere, do they have a permit? If they have a permit, do they meet the 30,000 square feet and the 40,000 for the house or the camp? Do they have a septic system separate from the camp and meet all the requirements? What I'm saying is, I'm willing to abide by Chapter 1000. Do what the ordinance that the town has adopted, do what the DEP rules say that we have to do. I'm willing to do all that, but I'm only willing to do that if it's applied to everybody else. So if the code enforcement officer is going to make sure that from now on, everybody is going to comply with Chapter 1000, I'm willing not to argue about our camper on our house, our camp lot 468. However, I still have a problem about not being able to store it there, because this is a recreational vehicle, and that recreational vehicle is on its wheels and licensed just like a car, a truck, with a pickup, with a camper. And there is no, unless you can show me in the code book where it says that that is a violation of the ordinance, then I believe that Denise Dupatti went too far in her claim that we had to remove our camper from that lot for the winter and could not store it on our lot. Get that?
Okay, I was listening to you about the 1000, code 1000, okay? And I'm thinking, I've got a small lot myself. It's grandfathered. It's 50 by 100, I have a camp, I've got a septic, I've got a shed, okay, so on and so forth. Well, if the town, do you expect the town to come to me and say, hey, you can't use your lot anymore? Okay, because mine's been grandfathered, was built in 1956. Okay, so there's a lot, yes, you're right. There are small mobile homes, small type campers next to the water, but they've been there for years. But today, now.
I didn't hear what you said then.
Okay, I see a lot of small campers near the water.
No, just the last part.
Okay, and they've been there for years. Okay, the camper's been there for years. They're grandfathered. Now, there's some empty lots around the lake. Okay. Now, on this empty lot, if I would have an empty lot, or a farmer would have an empty lot and wants to put a camper there, then they would go with the new laws. But you cannot expect a person that has a camper next to the, 50 feet from the water, whatever, and it's been there since 1950 or 1960, to remove it. Because at that time,
that's grandfathered.
yes.
The others are not grandfathered.
Say again?
The campers that are around the lake right now are not grandfathered. The only one that I'm pretty familiar with all that. I've been around and I've looked around. I'll tell you one that I think that might have been grandfathered there would be Frank Peltier. You know what I mean? Next to
yes.
we're done. I think that one there would be grandfathered, and I would agree with you that it's been there before the code, so it would be grandfathered.
That's right.
I talked to Colin Clark, and he made clear to me that it is not allowed, if it's not grandfathered, if the camper is not if it's been moved off that property since 1976, since we adopted Chapter 1000, then it is not grandfathered. Then that camper is not legal. It cannot, under any circumstances, he told me, not even with a barrier, be allowed to be within 100 feet of the lake. I accept that from him. He's the authority on this, and I'm not going to argue with Colin Clark. Colin Clark made clear to me, if the camper is not grandfathered, it must meet all the requirements of Chapter 1000. Otherwise, it's illegal.
You've got to find out whether they're grandfathered or not. Now, what's the year?
I didn't hear you, Dennis.
What is the year of the so-called grandfather? Can anybody here have an opinion on this?
Your camp is grandfathered.
Oh, yes, it
But
is.
you cannot bring a camper there, because the camper is not grandfathered.
Okay,
And now it has to meet the requirements of chapter 1000.
I'm not saying that I want to bring a camper there, but I'm just saying that, you know, what do you expect the town to do? Okay, if somebody has a small camper that's closer than 100 feet, because the lot is not even 100 feet from the water, they don't have the rule. It's been there for years. Do you expect the town to go and tell them, hey, you gotta remove your camper?
Well,
Okay,
that's what Denise did to us.
Mr. Chairman, may I just be heard on one particular point? May I, Mr. Chairman?
Go right ahead.
Thank you.
Yeah.
So, Mr. and Mrs. Kerr filed an appeal concerning lot 468. It's not this board's jurisdiction, again, to be dealing with how the town may or may not be handling any other lot around the lake. We're talking about lot 468. The question before the board is whether lot 468 can accommodate a recreational vehicle. And in order to do that, as you see in the record, the email from Colin Clark, who, by the way, is the head of the Maine DEP Shoreline Zoning Department, he's made it pretty clear in his email to Ms. Creary that you just can't have a recreational vehicle within 100 feet of the shore, period. So we're dealing with lot 468. If this issue also arises on other lots, that's something for us to address, but it's not something that the board needs to take up in connection with Mr. and Mrs. Kerr's appeal this evening. This is about their lot. It's not about other people's lots. It's about their lot. This board doesn't have any equitable powers to be determining whether there's selective enforcement going on here or not. Mr. Kerr has filed his appeal. Again, it's an appeal from a notice of violation, again, which this board has no authority over. I can understand his frustration. I can certainly understand if he thinks he's being treated differently. But that's not a topic for the local zoning board of appeals to address. If Mr. Kerr thinks he's being dealt with differently than others, and if he can prove the selective enforcement matter that he's brought up to this board to a judge, then by all means he should have an opportunity to do that. But just like the constitutional issues that he has raised, it's not something that is within this board's jurisdiction to deal with. This board is here tonight to hear about the facts concerning lot 468 and nothing more.
Well, let me say again, there are more than one issue here. The other issue that I'm giving up on the requirement. I do not meet the requirements of Chapter 1000. I feel that it should be applied evenly, and everybody should meet those requirements. Let's put that to bed. Now we have one more issue here. The other issue, there's two other issues actually. One of the issues that I'd like to get at right now is that Denise Dubadie made a determination, and that is something that you have jurisdiction, because this was not a notice of violation because it never happened. She just told us what she interpreted the code to mean, that we could not even store our camper there. I disagree with that. I believe that this is storage of a camper is not an individual private campsite. It's closing it up for the winter. Like I left my boat and my truck there. I believe that because it's on license and on wheels, I should be able to leave my camper there as well. Next year, I'm going to have to move it off that property and use it somewhere else. My contention is, my point is, I asked Denise in an email to cite the ordinance, the statute, or the law that says that I cannot store my camper on my property, especially if it's licensed and on wheels, and it will be removed next spring. But she would not allow me to do that. That, I believe, is within your jurisdiction because it is not a violation. There was no violation. It never occurred. She just told me that if I don't want a violation, that I have to remove it by September 16th. And I cannot store it there. Now that is an issue before you that is within your jurisdiction.
Is there any other issues that you think is within our jurisdiction?
Yes, the other issue I'd like for you to address is that when I filed an application for a meeting or a hearing with the Board of Appeals, whether it's a variance or an administrative appeal, that the code enforcement officer does not have the right or the authority to deny us that hearing. That's why I didn't mail it to her. That's why I mailed it to you. And you have to make that determination to determine whether or not you have jurisdiction and if you want to have that hearing. That's your responsibility, not hers. It's illogical to believe that the code enforcement could deny an administrative appeal of her own decision. Well, then why would we ever have any hearings?
Okay, Mr. Is it okay for me to ask a question?
Yes, Dan.
Okay, I just want to make sure. Mr. Mayor, is it the, let's see how, okay, the Board of Appeals, can we just say, okay, and get a meeting going?
Well, you people, it's all in your handbook. You people should be referring to your MMA handbook. Everything is in there, and it's pretty clear. And if you have any questions, you should be contacting MMA. We pay, back years ago, we used to pay $5,000 a year for the advice, free advice for $5,000 a year. And we should be using those people to make sure that we do not violate people's rights. We follow the laws. We treat everybody the same. And that's what MMA is there for. That's why they wrote the book. And those handbooks are, if you look at the index, whenever an issue comes up, let's say bias, for instance, look in the index, it tells you which page to look on for bias, explains everything. Anytime you have a question, well, again, to your question, Dan, yes, what it says is that once you receive a request for a meeting or hearing, you determine whether or not you have jurisdiction and whether or not you want to have that hearing. You feel that it's justified. That's your determination.
What?
The planning board, it says that here, we don't determine that.
Not for practical, well, it'll start off with the planning board, but then when it goes to the planning board, then it comes in, sometimes it'll come to the Board of Appeals, depending if it falls within the codes of the,
The planning board has the same rule.
Okay, Mr. Vera, what's your opinion on this question?
Can you tell me what your question was again? I thought it was directed at me. I was having a hard time to hear it, and then Mr. Kier answered. So if you could try to repeat it for me, I would appreciate it.
Okay, is it the Board of Appeals? Okay, we each got a letter, okay, requesting to have a meeting. Okay, is it the Board of Appeals' duty to do that?
Are you asking, is the board obligated to respond to every request for a meeting or a hearing?
Yes.
I don't disagree with Mr. Kerr that perhaps the board has to meet, and the first question that it poses to itself is, do we have jurisdiction? I think in this instance, the September 7th communication from the CEO was a notice of violation. I don't know how you can characterize it any other way. And your ordinance plainly says that that's not appealable, so you don't have jurisdiction. I'm not sure I understand exactly what has gone on otherwise concerning efforts by Mr. Kerr to appeal to the planning board. And we need to hear from the code officer at some point this evening. But I don't disagree strongly with Mr. Kerr that he is entitled to have this board at least declare whether it has jurisdiction over a matter. And it might be that we don't get beyond that, and then we go home for the night. Do you have to respond to everything? I don't think that you have to if a request is so far out in left field that plainly you don't have jurisdiction, then you could instruct the code officer to just send a letter saying you're following the wrong process or whatever it might be. I've not encountered that before. Typically when boards receive an application, they do take action on it or declare that they don't have any jurisdiction. That would be simpler. We're here now. You can make your determinations about jurisdiction at this point. And I think that the rest is really just chatter on the sidelines.
There was something that I want to question you about this, Mr. Ed. There was something that Mr. Carrier was saying about licensed vehicles being parked on shoreline zoning. Is there anything within any of the laws under statutes for DEP allowing registered vehicles, trailers or pickups or boats or anything of that nature to be put on shoreline zoning lots within the 100-foot high water mark?
Who are you asking that?
I was asking Mr. Bayer that. Oh, can't hear you. Okay, I saw his hand, so
Thank you. Thank you. If you refer to your ordinance, page 16, that's the town shoreline zoning ordinance, subsection E, individual campsites, and it's the same section that I think your record of materials that were forwarded by the code officer for this hearing includes an email dated November 4th from Colin Clark to the CEO, and in it, it looks like this. It's got some highlighted paragraphs in it. In it, this is the same as your page 16 of the ordinance, and paragraph 7 states, when a recreational vehicle, tent, or similar shelter is placed on site for more than 120 days per year, all requirements for residential structure shall be met. So all requirements for residential structures plainly includes being more than 100 feet back from the water. So no one is saying that you can't store a recreational vehicle on a lot. It simply has to be stored more than 100 feet back from the water.
No, it's year round, not even for storage.
So if I'd like to comment on that. And what Mr. Bear is saying, and what, I understand something. If he's going to stop me from doing it, I don't have a problem with that, as long as he does for everybody else. So now, if you buy a camper, Dan, and you travel all summer with your camper, and in the end of the summer, you bring your camper on your lot that's grandfathered and not more than 100 feet from the lake, you will not be able to put it there if you listen to Mr. Bear. Mr. Bear is establishing that from now on, even storing an RV camper on your property, if it's within 100 feet of the lake, will not be allowed. If you're not going to allow it for me, make sure you don't allow it for everybody else. You see what the problem is here? We're making the town shoreline zoning code so strict because they're trying to prevent me from doing something. I don't have a problem with that, as long as you apply it to everybody else. Are you aware that the town of Sanigat has not adopted Chapter 1000 because it is not mandatory? That's why when you go down towards Sanigat, there's 3-4 campers right along the lake. They're probably 30-40 feet from the lake. It's allowed. They can do that. Now, if we want to put so many restrictions in Madawaska that we're not allowed to do anything anymore, so be it. You guys go ahead. I'm ready to move out of the town. I would recommend that anybody that wants to build or move around here, around Madawaska, go to Sanigat, go to St. Clair. Do not go to Madawaska because they will not. They'll make things so difficult, and they'll be able to crucify people. If they don't like them, like they don't like me, just bring enforcement actions. But I will tell you something. If you're going to bring these enforcement actions against me, I'm going to make sure that you bring them against everybody else. Now, I have something here that says, the $100 fine. Because I've told, for many years now, I've told them, if you're going to apply to me, apply it to somebody else. And they said, well, we'll address that if somebody complains about it. No, that's not the way it works. The code enforcement officer has a duty to go and drive around and make sure, especially now that you're going to need permits, she'll know that if there's a camper there, first, it has to have a permit. Second, it has to meet all the rules of Chapter 1000. And if she doesn't do her job, she can be fined $100. Let me. Okay. Title 38, Section 443 authorizes the Attorney General to take enforcement action against a municipality that fails to enforce its shoreline zoning ordinance, either by ignoring violations or approving applications which do not comply with the ordinance. And there's a statute that actually says that if the code enforcement officer doesn't do their job, we can bring a complaint and she can be fined $100 for each violation that she does not cite. Now, check Title 38, Section 443-A, number 3 also says that if you do not enforce a code violation, the Attorney General can bring any municipality that fails to adopt, administer, or enforce zoning and land use ordinances as required under this article is subject to the enforcement procedures, equitable remedies, and civil penalties set forth in Section 347-A to 349. In other words, shoreline zoning is mandatory. If you're going to follow the law, if you're going to have a code enforcement officer, they are required to do their job, and they have to enforce every violation that they're aware of. And they have to go, the code enforcement handbook says that every so often they should take a ride and check, make sure that there are no violations. That's their job. All I'm saying is, if you're going to have these strict codes, make sure you apply it evenly. And
I totally
you apply it to the same, to everyone the same. Yes, Ben.
I've got a question to Mr. Bear. Do you have the number 7 from this? Let's see here, from Mark Collins, where it says, when a recreational vehicle, tent, or similar shelter is placed on site for more than 120 days per year, okay, all requirements. That's fine, but most 6 months out of the year we have snow. I can see this as 120 days for the summertime. But, you know, I'd like to get further information about this paragraph. Because in the wintertime, obviously, nobody's camping out, as far as I know, around here. And so if it's parked on the lot, next to it there's a truck, a boat, a party boat, it's just parked there. It's not being used. So does that 120 days count for that?
Well, see that.
Well, I think you addressed the question to me, Mr. Chair.
Yeah.
Sure.
Thank you. So, when a municipality, whether it's Madawaska or any other community, adopts a shoreline zoning ordinance, it has to first be reviewed and approved by the DEP. If the town of Madawaska wants to have a different phraseology for paragraph 7 that you just read, so that it doesn't include winter months or whatever you want to do with that, you can propose that to the DEP. But unfortunately, the way our laws are written in this state, they get to decide whether that's acceptable or not. And they're the ones who have the final has adopted Chapter 1000, as Mr. Kerr refers to it, lock, stock, and barrel. It's not a unique tact to take. Most communities do that. Some communities with planning departments and what have you, and professionals on staff sometimes work on ordinances that vary somewhat from these provisions, and the DEP often approves them. But this is the ordinance that the town has adopted, and I think as recently as this summer, and it's what you're stuck with. If you want to make changes to the ordinance, then any one of you can certainly recommend those changes to the select board. They can be voted upon by the townspeople, and they can be sent off to DEP to see if they will agree. But if they don't agree, then the law is the law. The state of Maine has established shoreline zoning minimum zoning requirements, and these are those requirements.
Okay, very good. Now, so the town, okay, so we could recommend that number 7 be written in such a way that would allow storage during the winter months. Now, if we do that, that has to go to the planning board. And then the planning board goes where, once it's through the planning board, it has to be voted on by the town. Am I correct to understand that way? Or the board of selectmen, and then the town, and then the vote?
I believe that's correct. There's an amendment process in this ordinance. It's on page 2 of the ordinance. Just give me a moment. Amendments. The ordinance may be amended by majority vote of the legislative body, that's the town meeting. Copies of the amendments tested and signed by the municipal clerk shall be submitted to the Commissioner of the Department of Environmental Protection following adoption by the town meeting, and shall not be effective unless approved by the Commissioner. If the Commissioner fails to act on any amendment within 45 days, the amendment is automatically approved. Any application for a permit submitted to the municipality within the 45-day period shall be governed by the terms of the amendment if such amendment is approved. So it doesn't necessarily require a review by the planning board. It would seem appropriate that the entity, the planning board that might deal most regularly with the shoreline zoning ordinance, would make a recommendation to the town meeting as to whether to adopt the proposed amendments or not. But for now, on November 17th, 2021, this is the ordinance that we have. This is what the town has to go by.
Okay, thank you very much.
Well,
I agree with everything that Mr. Bear said. However, I'd like to point something out then, that in the town of Madawaska has adopted Chapter 1000, I can't remember if it's 20 or 25, 30 years ago. However, we had adopted it without number 2. Number 2 was not part of that Chapter 1000 that the town had adopted. And we adopted number 2 this summer as an amendment, exactly like Mr. Bear explained, how we can make an amendment. We added number 2, and number 2 is out for a reason. Number 2, I can tell you, and it doesn't affect me, it's not going to affect me, because it's not for, well, if you read number 2, it says, when an individual private campsite is proposed on a lot that contains another principal use and or structure, the lot must contain the minimum lot dimensional requirements for the principal structure and or use and the individual private campsite separately. That's what I was telling you. If you look in the municipal handbook, shoreline zoning handbook, the minimum lot standard for a legal lot or house or camp lot is 40,000 square feet. You're lucky then your camp, like mine, is grandfathered. However, if you want to place a camper there, you have to meet the requirements of the additional 30,000 and 40,000. So you would need almost 2 acres to have a camper on a house or camp lot. I think the town made a big mistake by doing that.
Well, maybe
nobody in the town of Madawaska is benefiting from that except one person or 2 people, and then I. You know why? Because this is going to prevent anybody from having housing camp lots with recreational vehicles, and they'll have to come to our campground.
Okay, well, that has nothing to do with tonight, I don't think.
I'm just pointing out that we have a very strict rule. We just made it more strict this summer.
Well, that's okay. It happened, it happened.
They can park.
Okay with me too, because it's good for our campground.
Not according to this.
Not according to this.
Okay, so what I would, once we have our own meeting, okay, I'll talk about it. Okay, we're still on what? Public comment? No.
I'd like to hear from Denise if possible, before we go into public comments.
Well, there's a lot here today,
Yes, there is.
but, following Ed's advice. So it all started, and you have my written statement, and you have all my minutes, and what happened, when, what dates, where. So when I came on, there was an application in front of me for the RV to be parked on that lot. It went to the planning board, which they said it might be feasible if you have a septic system that's in play. And it's the reason Don DeShane went to check out their current septic, which they've been using all summer. And basically we're told that you need to put a septic across the street or across the way, the right of way. Because the current septic wasn't cutting it. And Mr. Kayer said that he was gonna make that happen. So we move forward, we keep going, still parked on the same septic. I go establish the 100-foot mark, the camper is in the 75-foot mark. So we have a conversation. He says, if I move my camper outside of the 100-foot mark, then I'm on the road, basically. And I said, yes, sir, that's pretty much what it is. I'm just following what it says in our ordinance. So at that time, he told me, I asked him again about the septic, if it was a happening thing. He said he had a plan in place, but he couldn't give me the plans, nor could he give me the name of the contractor. So with that said, I had to act on the camper having been there with his own admission on the date that he parked it in May. So I went back 120 days. I did give him that whole 120 days, but nothing had moved, nothing had changed. He had actually bought in gravel to do the pad underneath the camper, or so he wouldn't step out in the grass, without a permit as well. So we're looking at different things here that were happening without permitting. And there's more. So the next time that Mr. Kayer sent, the first time in September, when he sent you an administrative appeal request. The administrative appeal was based on greatest practical extent. He was saying that, he wanted his hearing greatest practical extent or whatever. So that administrative appeal hearing was a moot point because the greatest practical extent on an RV, one, it's not an existing structure, and two, we were meeting over something that basically was, and we had that discussion. And it was a moot point, so hence the reason I sent back to Mr. Kayer saying I'm filing this administrative appeal, and on legal counsel, it's not my job to say, well, refile it in a different way. That's on Mr. Kayer. So then Mr. Kayer asked me for a greatest practical extent, and he was unaware that the planning board does have the right to have a designee, and I do have that, and I provided you with those minutes, and that was before all of this happened. They gave me the designation for greatest practical extent along the shoreline because we had other campers that had replacement or issues. And most people that do apply for them do get a greatest practical extent because one, they're existing, and two, they back up. I tell them, give me a foot or two. I go through DEP. DEP approves my decisioning, and then, you know, the landowner gets what he wants for his camper. So Mr. Kerr wasn't aware that I had that designation. He's saying that that's not applicable. They can't do that. They certainly can. It's in our ordinance.
DEP can?
No, the planning board can establish designation, can give their GP, greatest practical extent for shoreline, to a designee. I am their designee, and it says it right in our ordinance.
Okay. But as far as what you're doing when you're going up to the lake and you're finding a camper, let's say, or something that's within the 100-foot shoreline zoning, let's say, I'm not talking about the carriers here, I'm talking about anybody.
Yep.
They're going all the way out to the other side of the golf course and heading out that way.
Yep.
Whatever's within town, whatever's within town Madawaska. Have you come across other camps that were not grandfathered, or campers that were not grandfathered within 100 feet, the 100-foot high water setback?
I did observe that there are maybe 2 or 3 that are not within that setback.
Okay.
They haven't been there 120 days, and they have a porta potty on the side.
So the porta potty, they're not using, they have a porta potty separate.
Correct.
So they're not using the, as far as you know, they're not using the facilities within the camper.
Correct.
But,
They have to either have a pumpers agreement
okay,
or a porta potty.
is that within?
And
Is that within the 100-foot high water mark or over the high water mark, the 100-foot water mark?
they're supposed to be outside the 100.
Now, that's the other thing. Are these campers outside the 100-foot water mark, high water mark, with a,
Some are.
okay,
I have observed a few that are not.
okay,
Knocked on doors, nobody home.
okay,
So basically the camper gets parked, and they come, they use it for a week, they leave. I don't know where they're from. So I try to catch them when they're there.
okay, well, do we have an address on file for them where they're paying the tax bill so we can send them a letter?
Sure.
Can we do that? No, it's, you know, it's gotta be fair, you know, it's just like the same problem that I had on Park Street.
Yeah.
Okay, I made a decision, I was gonna tear down a building to make room for town snow, and that's what I'm gonna do. Okay, I went to the Board of Selectmen 3 times, they denied me all 3 times, no problem, but it's gotta be fair with everybody.
Yeah.
We can't go after one group without going after another group, people, no matter who they are.
So right
Okay.
now we're talking about Mr.
Exactly.
Kayers,
Yes,
and you know, and his application before me again was to place the camper within the 100.
Right,
And the conversations with the planning board
yep,
were, it probably could have been a possibility, but they're going through the back door trying to come in through the front door. So, you know, first there's the application for the camper.
Mhm.
Second, there was the discussion, you know, okay, what's your greatest practical extent, if any? And there's not, because it's a camper. And the next one was, what about your septic? Because the one that you have now is not right. So we need a written pumpers agreement or a porta potty, which they never did. And we kept asking for it, but they didn't.
and is that to put the camper within the 100-foot high water mark for 120 days?
The camper was there, and we asked them if they had an agreement because we didn't want them plugged to their septic system that they had there.
Okay, what was wrong with their septic system that they had there?
That's something you're gonna have to ask the LPI,
LPI?
liquid
Yeah,
plumbing,
the,
the licensed plumbing
You're
inspector.
talking about,
Dawn.
Dawn?
John.
Dawn's not here, so I can't ask him.
Yeah.
Okay,
But from what I'm understanding from Dawn and Mr. Kerr was they were going to look into putting a septic system.
rebuilding a septic system
Yes.
Across the street.
across the street?
Yes.
Would make a lot of sense. Takes everything, just moves it across the street instead, it pulls it away from the lake even more, so it makes more sense to do that.
Correct.
But, out of sake of discussion and an argument, let's say the Cares did do this, okay? I'm just trying to, what I'm trying to do is try to tackle this at all different angles. Every single angle that I can possibly think of. Let's say, Mr. Kayer, they decide, okay, we're gonna redo the septic, and they dig a trench across the street. It's their private road. It's not gonna be shut down for any length of time, and they go there and they go across the street. And let's say it's Ed Pelletier and Son that goes there and does the groundwork and builds a complete septic system with a leach field, and they set up and they plug into it. Can they still park their camper within the 100-foot mark?
No.
Or 128? So no matter what, they cannot park within 120 feet, 100 feet of the high water mark.
Not without variances and all
Even
that
with
stuff, but it's not
variances.
gonna happen.
Even with
So
variances,
even with-
DEP
Correct.
still got to weigh in on it.
Correct.
So the only thing that he has to play with there is basically 20 feet.
Yes.
So if the camper's 20 feet, we can't even grant a variance because it's already on the line.
Right. The camper is 8 feet wide.
The camper is 8 feet.
8 feet wide.
So if his camper is 8 feet and a 20-foot, if he puts one set of wheels right on the 100-foot mark, he's got 8 feet. We can grant him a variance for that all the way down to 5 feet. To
The
park
only
the camper
variance
there.
that he would need would be from the road.
Grant a 5-foot variance from the road, and then he can leave his camper there year round. They don't
But
follow.
he has to park it horizontally.
Yeah, I don't see why he couldn't do that. How long is the camper?
He probably could answer that.
How long is your
better.
camper, Mr. Kayer?
Can I explain something to you?
Mhm.
I talked to Colin Clark yesterday. There is
Yeah.
no variance. There's no way I can put a camper on that property.
Right, and I corrected myself.
I will not be putting a camper on that property. But Denise has been telling you it. And I have a right to rebut what she said. And I'm telling you that it is not legal for me under Chapter 1000 to have a camper on that lot.
Correct.
I do not plan on putting it there. I will not argue that. What
Correct.
I'm arguing is I do have a right to put it there over the winter. Now, that is not, if you have questions about that, you have a legal right to put this on hold and find out. And I would recommend that you talk to MMA and to Colin Clark. It doesn't cost anything.
Mr.
And
Kayer,
find out-
if you leave it,
Find out what you're allowed to do, because what I'm saying is we have Chapter 1000, it has to be followed. Here is the title I was trying to find a while ago. Title 30A, 2607, neglect of official duty. A municipal officer who neglects or refuses to perform a duty of office commits a civil violation for which a fine of not more than $100 for each offense may be adjudged, and when no other penalty is provided, the fine shall be recovered on complaint of the use of the municipality. Now, let me explain something here. Denise is telling you that she doesn't know who owns them. The one next to Charlie Albert, Charlie Susi, you've seen that one. It's been there for 3 years, hasn't moved. She knows who owns it. It's licensed and on wheels. Look at the license number, go to the police station. You get the license number, you put a notice of violation on the door. She is supposed to do her job. She's trying to explain to you that she could not do her job. That's not true.
so Mr. Kayer, the camper might have been there for 3 years.
I didn't interrupt you. Will you please let me speak? Denise has
That's a little bit over the top, Mr. Chair.
Pardon?
That's up that, you inserted yourself into the CEO's presentation to the board, and now you did. Yes,
I
you
did not.
You did. And
I
now
have a
you,
record here, Mr. Bear.
and now you missed
You're
it.
interrupting me right now.
No, it's not your floor right now, it's the CEO's floor. You assumed a rebuttal position that you're not entitled to just yet. And you assumed it, and then you went on to spew on about a statute that has nothing to do with the code enforcement officer's discretionary duties. That has to do with the mandatory duties of an assessor or a clerk who's used to process something. So, really, these sideshows are not helpful in getting to the question here, which is whether you are entitled to have your RV on this property for more than 120 days and closer to the water than 100 feet. That's all this hearing is about. Everything else is a sideshow.
Are you done, Mr. Bear.
I'd like to turn it over to the CEO who was speaking before you assumed the position that you did.
And then I'll have a chance to rebut her.
It's not up to me.
Thank
I
you.
don't see where you have a God-given obligation or duty or
Would you
right.
like me to read the statute, sir?
And the statute is not governing this particular process. I don't care if you talk forever. I really don't. But why don't you let her finish?
So I started in July, and like I said right from the beginning, what I had in front of me was an application to place a camper within the 100-foot mark. We tried to work with the Kayers, and he's stating himself it has to be outside the 100-foot mark. And that was my understanding as well. Hence the reason I had Scott Belair come and show me where the high water mark was. And Don DeShane was there. And they put a stake into the ground because where Mr. Kayer was saying where it was and where it actually was two different things. Then I could establish a 100-foot mark and he would see, and I put a stake in the ground, the 100-foot mark, and he did have that space to move his camper if he really wanted to keep the camper on that lot, to move it there and get a variance from the easement from the road, 5 foot instead of 10, and then put his septic on the other side. Now, as far as the storage is concerned, the camper had been there for over 120 days already. There was, the violations or whatever could have started way earlier. No pumpers agreement, no, porta potty, no nothing. Trying to work with him. He's going to the planning board, trying to grade his practical expense on camper. That's just not going to happen. So, there had to be a drop dead date. And the drop dead date, he told me he had parked it on May 17th. So that made it over 128 days on September 16th. He had 120 days in his camper, hauled and graveled, plugged to a septic system that he wasn't supposed to be plugged to, never gave us a pumpers agreement. There was a lot of things going on there, trying to work with him on this one particular application. He kept bringing up a lot of other stuff, and I kept saying, Mr. Kayer, I'm working on getting you to place this camper properly on this lot.
But the chapter 1000 rule, like Mr. Kayer is talking about, that is strictly within shoreline zoning.
Right.
Okay, that's 100 foot shoreline zoning. No?
Yeah.
Shoreline zoning goes beyond 100 feet.
Okay.
Yeah.
Shoreline zoning is 200 or 250 feet. 100 foot is a setback.
Okay.
Right.
But the width wise, it's higher and it's higher than that.
And he has a non-conforming lot.
So it has got a non-conforming lot. Okay. So in other words, you followed everything to suit. Did all the hoops jump through everything?
Yes. And I always consulted with DEP what my options were, as well as legal counsel.
Because we as board members cannot call up MMA directly.
Right.
We have to go to Gary, because that was something that was determined by the Board of Selectmen a number of years ago. And we can't go directly to MMA, but we tell Gary the question, Gary can go to MMA with the question.
Right.
Okay, that's far as what I've heard quite a bit about.
Yep.
Okay, so we cannot go to MMA directly. That's the unfortunate because sometimes it could come in handy. We could go directly, but we can't. Okay.
Mr. Kayer, I have a question for you. Can I ask why you didn't proceed to park your trailer in that very little space that you have?
I'm having a hard time hearing you.
Can I ask why you didn't proceed to try and park your trailer in that very little space that you have and park it there?
In the space, there's trees there. I would have had to get a payload or something, a forklift to lift it up and bring it inside with. The lot is 48 feet wide. There are trees in that section over there. And I'm not sure if I even have 35 feet left to put my camper in there. My camper is 35 feet and certainly can't turn it around. There's fences there. I certainly can't drive it there. I would have had to pick it up with a forklift and bring it there sideways. it was just an unreasonable request by Denise. I felt that she was laughing at me when.
Well, it could be easier than deflecting guidelines. You know, you would stay within the means of the guidelines. That's what she was trying to do. You would.
I can't meet the guidelines, and that's why I moved it out. I didn't violate any rules here.
Okay.
She told
No,
me what the rules were, and I obliged whatever she said. I didn't argue with her. I just moved it, and there's no violation. I'll tell you, like I've said for years now, tell me what the rules are for everybody, apply them the same for me, and you'll have no problem with me. I've never violated the shoreline zoning rule or ordinance. I've always stayed within the law, and I intend to continue that. I'm just telling you that our code has become so strict. However, they're not applying it to other people. You people have driven up there. You've seen campers. They've been there more than 120 days. Some have not moved for 3 or 4 years. And they don't have septic systems. They're within 100 feet. They're in violation of Chapter 1000. That's why I believe that if other people can do it, I can. And I argued that, and I lost. I moved the camper. I'm not going to put it back. And now all I'm asking is to make sure that she applies the rules and the laws for everybody else. When she told you that she didn't know who owned it or was there for a short period of time, they weren't there, I was told that I needed to get a permit. Do they need permits? If they need permits, you must know who's there. It's illogical what she's telling you. It's not true. Now, there's another issue.
Hold on, Mr. Kerr. Hold on. What was that? You had raised your hand there.
Yes, can I answer to that question?
Yeah, go ahead.
So I've been here since the middle of July. That gave me July to August to September, which is your camping seasons, right?
Yeah. Yeah.
So he's quoting about campers that were there 3 years ago, whatever. I wasn't here, okay?
Yeah.
So if you're looking along the shore at these campers that were there this summer, as I'm coming in, and I'm dealing with building permits over building permits that have been stacked up for a lack of CEO here for several months.
Yep.
Okay? I'm doing my job.
Yes, and I'm very much aware of that. I'm very much aware that you're new. It's just like me when I drove semi trucks. You know, I didn't get in the behind the wheel of a semi truck and drive out to California with the back of my hand. I needed a map to get out there. I needed a map to come back. You did that 3 or 4 months, but after a while you learn it. No big deal. You just go. It comes second nature. It's the same scenario as being the CEO. It's just a lot more politics involved with it. Okay. Yeah, hold on. Now, I'm just concerned about here on. That's what I'm concerned about. If we're going to crack on him, if we're going to crack down at the town and the cares, we need to do it with everybody. And he had a good point. I mean, these trailers have a license plate attached to them. It may not even be registered anymore, but that license plate is still somewhere along the line. And they can tell you, going through the PD, they can tell you who's the one that had it registered last. Correct. That usually stays on the state files.
So, correct.
And then you can go from there. That you can find out it could have been Mr. Ecker that had it, but he sold it to somebody else. And who sold it to somebody else? Okay, and I understand where he's coming from.
Me too.
Okay, we all understand where it's coming from, but it's from the here on now. Right. So, in other words, I don't like to see the favoritism.
There's no favoritism
I don't want to see it.
Or discrepancies.
Yeah.
And the campers he's talking about, I don't even know these people. So, you know, moving forward, I'm going to do my job to the best of my ability.
Yeah.
And I'm going to follow the rules just like I do with Mr. Kerr. Yeah. I had an application in front of me.
Yeah. Yeah,
I was acting on the application.
You started with an application. And
Correct.
Right off the bat is what you started with.
Correct.
Which I understand that. Okay, can we open this up to public comments here a bit?
Can I say something first, Mark?
Yeah, go ahead.
In order to be legal within shoreline zoning, it has to be registered legally on that year, every year, and must be on the wheels. There are other requirements that are not being met. And if you see the license and it's outdated, it's illegal.
Mr. Chair.
Okay, I got Gary over here that would like to say something. Go ahead, Gary.
Camper does not have to be registered, but it needs to be property tax, real estate tax. So if it's not registered, the town should be assessing real estate tax on it.
So if it's not registered, the town can assess real estate tax on it.
And we're supposed to.
And you're supposed to. Okay.
So it does not need to be registered to be on the lake,
Okay.
but it would have to be excise tax,
Property
assessed
tax.
property tax, excuse me.
Okay. Okay. Yeah, registered, moving around too. Okay.
And another thing Mr. Kerr was talking about, picking up his camper with a forklift.
Yeah.
I have a massive fifth wheel.
Yeah.
So I know what kind of camper you can park in what size.
Mm-hmm.
Most campgrounds don't have big sizes, but you get it in there, don't you?
Right.
There's a way to back up a camper
Mhm.
to where it needs to be and to
Yeah.
park it.
Yeah.
So, you
I'm
know,
very much- I'm very-
I mean, the theatrics and the drama of moving the camper, you know, if he can't move it himself, there are people you can pay to move it.
Yeah, I'm very much aware of that. So, like I said, I'd like to open up this up to public comment if there's any. No public comments? Does Mr. Ed Bear have anything else to throw into this?
I have a
No,
comment.
Mr. Chairman. Thank you very much.
Okay.
I have a comment.
Okay.
A recreational vehicle, the definition in the shoreline zoning, a vehicle or an attachment to a vehicle designed to be towed and designed for temporary sleeping or living quarters for one or more person, and which it may include a pickup, camper, travel trailer, tent trailer, camp trailer, and motorhome. In order to be considered as a vehicle and not a structure, the unit must remain on its tires on the ground and must be registered with the State Division of Motor Vehicles. That's a license. Gary Picard is wrong.
That's if you're gonna be registered with it, but what happens with a recreational vehicle that is parked somewhere here in town that's not registered? Now it becomes a permanent resident. So now it can, instead of being registered, it's being taxed as property tax, because now it's a structure on a piece of property.
I just read you the shoreline zoning definition of a recreational vehicle. It has to be licensed on wheels. If it's not licensed, it's not legal.
Really not the issue before this board tonight.
Correct.
Yeah.
Thank you. Okay, I make the motion that we adjourn the public hearing
Yes.
and start with the public meeting.
The public meeting. Are you sure?
For our article adjournment and then judgment on,
Yeah, not a problem.
the public meeting. Okay, this is the public hearing we just did,
Yeah,
and now we have our meeting.
so you made a motion.
I made a motion.
I'll second it.
All in favor? So that was done. Now we go into the public meeting. Notice of agenda, judgment on the above mentioned case of business adjournment.
Okay, as Mr. Beer said, a lot of this, the articles here.
Yeah. And I do agree with him on that. A lot of it.
October 14 does not pertain to our code, to our appeals. Okay. I would recommend or suggest that on the last page of this, okay, number 7, about putting a recreational vehicle more than 120 days, okay, that we would bring it up somehow to have that exclude winter months. So that way, a person can have an RV, okay, for 120 days, that's fine. but they can park it over the winter, because obviously nobody's gonna use it over the winter. And then the next summer, okay?
Nope, not gonna work.
So what happens on a lot, if you're gonna leave something on a lot, it doesn't matter if it's camper, truck, boat, etc.,
Okay,
you cannot have more than 30% impervious area. That includes fireplaces, swing sets, jungle gyms, sheds, trucks, wharfs. So your whole area cannot be more than 30% impervious.
okay.
So that's really for the DEP to change. It's not really ours.
Okay, well, anyway, that's just my thinking, and
But the problem is that even though you were to change Article number 7, okay? That if we were to change Article number 7 to the way your suggestion, now you're gonna have problems, okay, if they took the camper that they have, and they're gonna wanna use it there for the 120 days. So basically, the camper never moves. So this
Okay.
is the reason why that this Article 7 is the way it stands. They're not gonna wanna move it. Okay, even for the winter months, they're just gonna close it up and it never move. Okay, so basically, you just went from 120 days to 365 days a year. Okay, and that's the reason why this article was written the way it was, no more than 120 days.
okay, in that light, I think we're.
Okay, when you flip the coin to the other side.
Yeah.
Okay. As far as what Denise is doing, or what Denise did, I mean, this is green to her here. Getting mixed in this in July, I mean, this is not an easy thing to get mixed up into right off the bat when you have probably a stack of permits like this, that you gotta go through, figure out what's gonna have to be approved for permits, and then having Mr. Kayer's permit in the mix of that also. So I think she did the best that she could with her abilities. That's really what I think.
I agree, and I think Mr. Carrier should consider parking where he has space and maybe cutting off those trees and using that space if he wants to.
The problem is, even to use that space like you're suggesting, he's still gotta get a variance to park it there. Because he's within the town ordinance on that is 15
But
feet
it would be
from the lot.
more doable than your 100 feet.
Still gotta go to DEP, because again, you're falling back under the 250-foot mark from the lake.
But within 100, he's not gonna get anything pretty much.
No, you won't get
So he's
anything.
got a better chance to go
Right.
that way.
Right.
Okay, our job tonight is to review and overturn the CO's decision denying us the right to the Board of Appeals hearing. Well, we are having the Board of Appeals hearing.
Right,
Okay.
because he sent all these letters to us directly, which in turn, we should have all brought the letter here. Because,
We do. It's here.
right, it is here now, but we should have brought the original letter when we got it in the mail, we should have turned it in the town office. Because under the town ordinances, from my understanding on our town ordinances, it's not the Board of Appeals who set up meetings.
That's what I
It's
understand
the
too.
CEO and the town manager that set up the meetings. We do not have a charter in town. Under a charter system, it's a different ballgame, but we don't have that. Okay, we have to go through whatever, I know Denise called me up, when was a good time for me, when's the good dates for me? Yeah, I work for myself, so it doesn't matter, okay?
I got the same phone call.
Yeah. So you could say it's just Paul over here because of his schedule, or the other Paul that's not here tonight, okay? Any other suggestions?
So, what are we gonna,
Basically, he's asking for us to deny his request on what Denise had done, if I'm getting this correctly here.
Storage.
It's winter storage.
It's not just storage, it's not storage. No, he basically wants the Board of Appeals to overturn Denise's decision to not go through the planning board. But that's a planning, what's that you're saying?
I don't believe that.
That's not in your jurisdiction.
That's not.
Yeah, that's not our
that's what it-
jurisdiction. It's not. Okay, so as far as what Denise is doing, I mean, we can't make that decision for the planning board. She's assigned to the planning board.
So it's a no contest.
It's pretty much it. I mean, there's not much that we can really do here according to what Mr. Ed Bayer had said. There's really not much that we can do here,
Okay,
okay?
I can make a motion to dismiss.
dismiss
May
the
I-
case.
There's nothing we can do.
Mr. Chair,
What?
could we ask the attorney if the Kayers are entitled to a decision up or down? Or if there's nothing to vote on here? I'm not sure that's clear.
Okay,
I'd like
let's
to-
do
I'd like
that.
to hear-
Mr. Bear, Mr. Ed Bear, are you still there?
I'm here.
You sure you didn't, okay. Did you hear Gary's question?
I heard part of Gary's question, and tell me if I'm wrong. I think he asked whether the board needs to make a decision on the appeal, i.e. deny it or just simply say it doesn't have jurisdiction. I think it doesn't have jurisdiction for many of the issues raised by Mr. Kerr.
Mm-hmm.
I think the ultimate question here probably is one that you don't have jurisdiction over, which is simply, does an individual who has been served with a notice of violation have a right to appeal? I think the answer to that is no, and the board could simply make that determination. And I think that that would be sufficient. I think the record that we've created here, assuming that this is being recorded in some fashion, establishes that the board accepts that it doesn't have jurisdiction over many of the items raised by Mr. Kerr, and that, section E7 of the ordinance, I don't know what the section number is, but page 6 of page whatever it was of the ordinance regarding section 7 simply says that you can't have a recreational vehicle there for more than 120 days. And that, the board finds that you can't, and that Mr. Kerr can't. That's it.
Okay. So the bottom line, we don't have jurisdiction on almost all of this.
Answer this.
Cannot have it there.
What's that? No, you can't.
No, you can't. He's within the 100-foot line. And if you fall under the only way that you might be able to allow him to put it there, if he's up on the outside of the 100-foot mark, depending if DEP would allow him to do that. Because we're always falling back in DEP over here with the chapter 1000.
That's his only solution.
And the chances are he's not gonna put it there. He's too close to the road. He'd be better off putting it across the street, or he's better off putting it.
Either way, we can't decide that.
I know
It's
that.
not for us to decide.
I know that. That's his decision.
Which is why I would still like to make a motion to dismiss this case.
Yeah. It's not our jurisdiction
Because
to do
it's
this.
not under our jurisdiction.
Right, it's not.
It's not
It's not.
for us to decide. If we decide and the DEP finds the town,
Yeah, it's not our decision, period, because that's what we deal with variances. is what we do.
Okay, so what's the motion that we all,
we dismiss the case.
okay, because it's not in order.
It's not in our jurisdiction.
You need to state that.
I'd like to make a motion
Yeah.
that we dismiss this case
Yeah.
because it's not in our jurisdiction.
Second,
All in favor? There we go.
go for it.
Now, what the other thing is I would like to do while we're here right now is I believe we have to approve our minutes for the last meeting while I'm thinking about it. It wasn't listed on here, but I do believe we had minutes here for the last minute. Do we approve the minutes?
Here's one.
Thank you.
It was just so then.
Yep, it was Lynn, yep, I do remember it.
Safe travels.
Really
Safe travels, guys.
Thanks for doing your
Drive
job.
safe.
Yep.
Drive safe. Bye-bye.
Yeah.
Go in. On the other whole level, we'll have to catch up with it. So, now, do we approve these minutes that we just signed in the everything? We approve the minutes, make a motion? You make a motion, you make a motion to approve it? You second it, all in favor? Okay. There you go.
So, Mr. Kerr, do you understand our judgment here tonight?
I didn't hear it then.
Do you understand, or did you hear our judgment tonight?
No, I didn't hear you what you were saying.
It's not our call, it's the DEP's call.
It was an motion that we dismiss because of the issues brought up tonight are not in our jurisdiction. That's what we
What about
voted.
all the issues? I had 7 or 8 issues that.
It's up for the DEP to, it's the DEP that decides that.
And then like Mr. Bear mentioned.
I might suggest you try, getting, another permit to park it where you're actually allowed to in that little space. Unfortunately, if somebody else around the lake comes to us with the same problem, we're gonna have the same decision. It's not our jurisdiction. And if that you're allowed that little space, you might wanna, if you wanna stay there, you might wanna park it there, you know?
You don't seem to understand chapter 1000. Number 2 says, if I have another structure there, that other structure requires 40,000 square feet. It doesn't have that because it's grandfathered like Dan's camp. The problem is, even if I was to put it on that little 10-foot section, I need another 30,000 square feet. You don't seem to understand chapter 1000. There's more than one requirement there.
Yes, but that requirement is decided by the DEP, not the Board of Appeals. There's nothing we can do.
And I talked to Colin Clark yesterday, he made it clear to me that I cannot, under any condition, even with that variance, there is no variance. There's no way that I can have that temporary on that lot, and I agree with him. I agree with him.
So we decided.
The problem is, that's not the only issue I had.
Mr. Kerr, Mr. Kerr, through legal advice, okay, almost everything on here is all stuff that basically must go in front of a judge. Okay, it doesn't come in front of us, it goes in front of a judge. So I'm following legal, actually, not just me, but the rest of the board decided to follow the legal advice of Ed Baer, and we decided to basically, we have decided to dismiss this under the grounds of it wasn't our jurisdiction to make any decisions on this whatsoever. So that's what we voted on. And it went past, and it was unanimous as a pass on it. Okay?
You have my 2-page request for a administrative appeal. I would like a finding of facts and conclusion for each and every issue. And if that's what you're saying is that you don't have jurisdiction, just put it there as well. And then I can appeal that through the Superior Court. Thank you.
Anyways, I'd like to make a motion to close the meeting. It is now 7:24. Mr. Ed Baer, thank you very much for joining us this evening, and the same with Mr. and Mrs. Cater.
I second.
Who made the first motion?
Wasn't it you?
No, I don't make a motion.
Like a motion to adjourn.
Oh, the motion to adjourn? Second. All in favor? Meeting is closed. Okay.